Good morning, everyone. Thank you for your presence here today. We are going to talk about human rights in the compliance chain and the experience of the new German law. And we're going to also to show you our scenario from Brazil. I'd like to thank you, Dominique Strieder, once again for participating in this webinar here today and teach us, let's say, with his experience in Germany and Europe. And we are going to have as moderator Rafaela Cálcena and Raphael Soré. They are coordinators of our compliance and internal investigations committee. So Rafa, the floor is yours.
Thanks, Isa. So I have the pleasure today to present Dominique Strieder to you all. So Dominique is a partner in the area of compliance and commercial criminal law in the Frankfurt office of Eversheds, Sutherland. He regularly advises and represents national and international clients in the area of compliance and ESG, as well as in relation to internal investigations. The focus of Dominique's advice includes advising companies on the development, implementation, and review of compliance management systems and the conduct of compliance risk analysis. He also advises on the establishment of whistleblower systems and on supply chain compliance. Another focus of his practice is advising companies on internal investigations, often with cross-border context. He's also a member of the firm's ESG practice, advising clients globally on climate change and related social issues. So Dominique, just repeating what Cecilia already said, thank you so much for giving your time a little bit for us and explaining this new interesting law. I'll turn to Rafael, who's gonna speak a little bit about the Brazilian scenario.
Thanks, Rafa. Thanks, Isa. Thanks, Dominic, and thanks everyone who's taking a bit of the time of your morning to be with us today and to take part in this conversation. So my mission is actually to provide a little bit of context on how human rights on the supply chain have been dealt in Brazil, especially for Dominic's benefit, so he can contextualize that on his speech, and also to provide some food for thought on our discussions. So in general, as I think most of you know, Brazil does have a legislation specifically tailored for human rights and corporations. It is a decree from 2018, Decree 9571. However, such decree does not provide for any sanctions for the companies who do not comply with such legislation. So it's more of an advice than actually a formal legislation or regulation that will provide for sanctions. And I think that's probably one of the biggest differences with the German legislation Dominic will tell us about. Such legislation, such Brazilian legislation, does provide for the concern on how the supply chain works on human rights. I think we've been dealing in compliance for the past few years in Brazil with a whole bunch of discussions on what companies should have in terms of prevention, detection, and response concerning corruption risk. But in the past few years, we have been evolving a little bit more on compliance, also reaching other grounds, such as human rights. However, while such legislation does talk about compliance in the supply chain, it's also true, Dominic, it's not very clear in Brazil yet. It's a gray area on what are the responsibilities of one corporation concerning how its supply chain deals with human rights. We've been seeing some enforcement in Brazil in the past few months, I would say in the past few years, but especially in the past few months, concerning one specific pillar on human rights and supply chains, which would be the slavery and working conditions part. Brazil has been facing several enforcement cases in the past few months on big companies being charged by the government on modern slavery violations. Most of such cases, the workers did not work for the company itself, but the workers would be working for other companies in their supply chain. Nonetheless, in spite of the fact that the legislation is not very clear on where would the due diligence obligation stop, enforcers have been considering that the biggest company, the company that's in the end of the chain, is still liable, at least from a labor perspective, by human rights violations of its third parties. All that said, I think the scenario, and that's my wrap up here to give the floor to you, is that Brazil has been discussing this matter. I think Brazilian compliance professionals have been dealing with a challenge on saying, okay, what should I be doing from a preventive perspective? What sort of due diligence should I be implementing for my clients or for my company? But secondly, on what am I obliged to do, or what are the next steps on this going forward? Also, I think a lot of the companies are concerned. They are very interested in having a very good and comprehensive human rights program. But at the same time, they say, okay, but if I do that alone and my competitors are not doing anything, I'll stop working with a whole bunch of suppliers, and my competitiveness will not be where I want to. So the German legislation, which is somehow new, can shed some light and assist us in Brazil here to let us know where the frontier will be, what sort of due diligence is expected, I think Germany is in the forefront here. So what are you doing there? What should we expect going forward for German corporations? And maybe if this German legislation will become the FCPA for human rights. The FCPA worked for anti-corruption to somehow push for change in national legislations. Maybe this will be the case for human rights. The floor is yours. I think the challenge is big, but I think you are more than equipped to let us know. And I would just like to invite all of our attendees here also to include something in the chat if you have any questions. I think we'll have some time at the end so Dominique can answer them. Dominique, thanks for your presence again. The floor is yours.
Well, thank you very much, Raphael. Thank you, everyone. Thank you, IBRAC, for having me. It's always a pleasure to talk with Brazilian colleagues about Brazil, about the business relationships that we have, not only between Germany and Brazil, but obviously also Europe in general. And as you will see, there are a lot of developments in parallel in Europe at the moment. So as much as I, from a professional point of view, would like to be the new FCPA, I believe it's not going to be the case, but I will show why that's probably not going to happen. I prepared a couple of slides. So it works. So actually, a lot of the, I think, points that you raised in your introduction, Raphael, they are very much applied to the situation that we have in Germany at the moment. So this is a general overview of where we are coming from. And as everyone knows, the discussion has been going on for many years, actually for decades. We come sort of from a academic discussion, soft guidance, soft law approach towards a binding law, hard law approach. And also the question is, what's next, right? So this was, it's not the most up-to-date overview, but it gives you sort of the flavor from where we have been coming from. And in Germany or in Europe, and I think it's similar in Brazil and in other jurisdictions, we see a very fast and actually sometimes for the legislator, too fast development, in that public opinion is forming a lot of what is happening now. So the discussion or the discourse about human rights and the necessity to enforce them has obviously been around for a long time, but the question has always been enforcement. Now, I think there have been a couple of events, but in Germany in particular, and I think in Europe to a large extent, one event that brought significant change in the public discussion was the collapse of the building in Bangladesh, the Rana Plaza buildings with in April 2013. It was a collapse of an 8-story commercial building that housed several garment factories, and that unfortunately resulted in the death of more than 1,100 workers. The workers had been working in conditions with severe safety and labor rights violations, not based on German or European or standards, but also national standards were not complied with. And to be very frank, just like in the textile or garment industry, such working conditions are not uncommon to occur. So, for example, in other industries, like the food and beverage industry, especially in the extraction of raw materials, as well as the agricultural industry, for example, we see these working conditions. Rafa, you alluded to it a little bit in the case of slavery. But you just need to open the newspapers and you will see reports about improper working conditions virtually, I think, in all jurisdictions. It's not limited to a specific set of countries, but for example, we saw it in the case recently of workers working in the vineyards in New Zealand. You have it in the meatpacking industry in the United States. You have it in the agricultural sector in Germany, especially with a lot of foreign workers coming as seasonal laborers during the summer month from Eastern Europe. So it's a global issue that this law is trying to address. The Rana Plaza disaster certainly generated global outrage and increased the scrutiny of supply chain practices. And the other examples that I just alluded to, they had similar results. One must admit that depending on the severity, i.e. the loss of lives, media tends to bring more attention to it or less. And at times the interest of the media and the public also evaporates after a while. Nevertheless, this movement has been quite strong. And initially, it resulted in certain measures. For example, there was a formation of initiatives like the Bangladesh Accord on Fire and Building Safety, which aimed to improve workplace safety and standards in the country's garment industry. So that was a concerted effort with and the combination of foreign industries in the garment industry, but also national production companies. Following these events, the German as well as other government actually pursued first a path of self-commitment, right? So there were no hard laws really enacted. It was more self-commitment from the industry and the request to uphold certain standards and improve working conditions. And that started in Germany around 2015. And there was a period for a specified period of time after which the government said, we will review what has happened. And if it wasn't successful, we'll pass a new law. And actually, the review was pretty blunt. I mean, not even the industry players disputed that virtually no one was following any standards or trying to enforce standards. And then the discussion already in the previous government, but now in the current coalition government was pretty clear. We need supply chain legislation. And somewhat to the surprise, actually, also of practitioners, the law was passed and came into force on the 1st of January 2023. I say to the surprise of many observers, because in parallel, there has been a discussion going on about passing European supply chain legislation. And once the European legislation would be passed, it would apply to all member states in the European Union. And if it becomes law, it would also supplement or overrule the German legislation. That's why, unfortunately, I don't think we'll have the new FCPA here. It's pretty clear from what has been happening on the European stage that there will be a European supply chain legislation coming. And we expect that to happen. Actually, the final negotiations between the European Commission and the European Parliament are likely to start this summer. They are not too far away from the negotiation positions, but this is what we will likely see. Now, as I already said, these scandals or these accidents and catastrophes, they made it pretty clear that it's not only the purchaser or the customer, but it starts at the very beginning. The supply chain is global nowadays, and buyers and also producers are very well aware of that. So it's not an isolated incident anymore. One thing that is a relatively new discussion that has not been there in the focus of the media is the question of raw material extraction. So the discussion about supply chain legislation in Germany was mainly started, as I said, in relation to garment industry and maybe agricultural issues. But one issue that I think is very prevalent nowadays is the European Green Deal, so to say, which is the transformation of the entire European industry towards a sustainable industry, which heavily relies on photovoltaic, on electric vehicles, and so on. And the raw materials needed for especially the batteries, I think it's no secret that they are actually extracted under conditions that are far from any need to discuss whether they comply with health and safety or human rights standards. And I think this is going to be a discussion that we will see going forward. How can you align the commitment of certain jurisdictions or regions to transform their economy, while this is actually being done on the back of people in other countries that are working under these conditions. Now, let's turn to the German law, how it's been set up, because, I mean, it's not rocket science, first of all, and secondly, it alludes, and it's very similar to other laws that we see in Germany. So you have in France, you have similar legislation. The Netherlands, you have Norway, you have in the UK, the Anti-Slavery Act. So there are a lot of legal initiatives or legislations that have been passed. And I think if you actually look at what the requirements are, they are quite similar to a certain extent. So what does the German law require? The act applies to German companies as well as non-German companies, as long as there's a nexus to Germany. So there needs to be either the head office or principal place of business or the headquarter in Germany. As I said, the law is in place is in force since the 1st of January of this year, and it applies to all legal entities basically that are working that are operating in Germany and that have more than 3,000 employees. This threshold of 3,000 employees will be lowered to 1,000 employees beginning on the 1st of January 2024. The act also applies to foreign companies if they have an office in Germany or productions in Germany, and again, if they are above the necessary threshold. Now, what is covered by the act? It's similar to, I think, what you alluded to, Rafa. So the act itself does not create new human rights. It refers to existing treaties and laws. It spells out and basically extracts what are the human rights that are found into these in these agreements. So obviously there's a prohibition of child labor, which refers to the permissible minimum age in the respective jurisdiction. There's a prohibition of the worst form of child labor, which, for example, refer to very labor-intensive work, for example, extraction of raw materials in mines, or if it's related to the adult industry, then the limit is 18 years. Slavery or slavery-like practices, forced labor, HSE, safety standards, discrimination, stuff like that. Similar, it also makes it contains a general reference saying that violation or the harm of the environment, when there's an impact on humans and their human rights, is also prohibited by the Act. And specifically, there's a reference to, oops, that's too quick. There's a reference to certain environmental obligations that are included in the Act, which take into account that the due diligence obligations of companies include environmental related obligations arising from the Minamata Conventions, which involves risks in the production and disposal of mercury, the POPs Convention relating to risks from the production or use of certain persistent organic pollutants, as well as the Basel Convention, which contains reference to the risks from the import and export of waste. Now, what does the Act actually require? And I think it's important to go back to think, what was the intention? The intention of the Act still is to increase the working conditions and the safety standards of of people, of workers in supply chains. Now, companies must make a reasonable effort to ensure that they comply with the various due diligence obligations that I will come to in a second, and that these are not violated within their supply chain. So importantly, the Act only refers to the supply chain. So it doesn't go to the seller or the end user, for example. That is something that might be different under the European legislation, actually. The Act does not require companies to ensure that no violations take place. So they need to take a reasonable effort to ensure that they fulfill their due diligence obligations. So I think that is also something that we'll probably discuss afterwards when it comes to the question of, can a compliance system ever ensure that no violation takes place? That's not required under the Act. You need to take a reasonable effort. The Act contains express language that the mere duty of effort is established and no duty to succeed or guarantee that no violation takes place. The Act distinguishes between a company's own operations. So what does a company do in its own facilities? What does the obligation that a company has towards its direct suppliers? So whenever there's a contractual relationship with your direct supplier, and then the indirect suppliers down the supply chain. So in its own operations, the company needs to ensure that it fulfills the due diligence requirements. And it also needs to include the direct suppliers in its risk assessment in relation to identifying potential risks. That is not the case down the supply chain. So if I'm a company, I need to check, what do my direct suppliers do? I need to report on that. But I do not need to check further down unless I have noticed that something is going wrong. When do I have notice? Well, that's unclear under the law. So, for example, commentators have said that if there has been widespread media report, companies should know that something is going on. So, for example, there have been various reports about the treatment of minorities in certain regions in China. And arguably, companies doing business in these regions would be required, German companies, if they are within the scope, would be required to investigate that and then also review whether there are any risks associated to their own supply chain. Now, what are the specific due diligence obligations? So it starts with the risk assessment. So you need to check what is your actual risk. It's similar to the compliance risk assessment, but now focused on human rights. And the difference the difference is one of focus, right? So the compliance risk assessment looks at what is the risk in your own operations, whereas the human rights risk assessment is what is the risk for potential victims from your operations. So that is the difference in perspective that is required. Based on the risk assessment, you need to implement your risk management system. Again, similar to, I think, what we see in the traditional compliance field. Once that is done, companies are required to define roles and responsibilities. So, for example, companies, as an example, the Act, for example, says you need to identify a human rights officer. It doesn't have to be a human rights officer, but you need to find someone who's willing to take the responsibility for what's going on. And the person and the responsibilities bring some obligations. So, for example, you need to regularly report to the management once a year at least. You need to produce your human rights statement also once a year, which needs to be sent to the regulator and published on your website. You need to oversee the statement of principles, which basically says or is a description of the risks that the company has identified and how it intends to deal with it. It's about defining preventive measures based on the risk assessment. So the company conducts a risk assessment, identifies certain risks, and the question is, what do you do with it? So you need to explain, well, we implemented certain risk measures, for example, reporting mechanisms, or we hired certain professionals that train our people in order to mitigate the risk, and so on, grievance systems, and so on. Specifically, there needs to be remediation measures. So if you identify a shortcoming, you need to handle it. You can't just say, okay, I identified it, let's leave it there and move on. That's not sufficient. You need a whistleblowing system, which is not limited to your employees, but to anybody who's potentially affected. So it needs to be open to the public. And it needs to be ensured that any reports received are handled in a specified way, as specified in the Act. And as I said before, all that is happening continuously. So, for example, the risk assessment needs to be performed once a year. And then based on that, you make your report, you make your remediation measures, and that is a continuous process, and it's all accumulated in the reporting, which needs to be available for 7 years on your website publicly. And it also needs to be submitted to the regulator in German. And it's a standardized form that you need to submit the report for. And presumably the reason why they created this standardized electronic reporting system is to actually make or enable them to handle the tons of reports that they are receiving. So what they are likely doing is they will categorize the reports that they get and look at which are the main discrepancies that they see in certain areas. And those are the ones that they will follow up on. As I said before, there is a competent authority that has been tasked with enforcing the act, which is the BAFA, the Federal Office of Economics and Export Controls. And actually, in order to enforce the law, BAFA has set up a separate division that deals with nothing but the supply chain legislation. And their powers are quite broad. So they can act at the request of an affected person, or they can also initiate investigations on their own. They have extensive rights of information and access. So they can basically request the provision of any documentation that is relevant for any of the due diligence obligations under the Act. And if you think about, for example, the description of risk management is so broad, you can think of virtually any information request that you can think of that falls under that language. And the enforcement agency can also ask the company in question to implement certain measures in order to comply with the legislation. Standing under the Act obviously have affected individuals, but interestingly, also trade unions and non-governmental organizations that are authorized by an affected person can conduct such litigation. The fines are quite severe under the legislation. So for companies, it's up to 8 million. Or if they have an annual turnover of more than 400 million, it may be up to 2% of their average annual turnover. So that's group-wide. And they can also be excluded from public tenders for a period of up to 3 years. That was a very quick run through the Act, and maybe just to come to an end and give you a brief outlook on the European Corporate Sustainability Directive that's actually being discussed. It's very similar in scope, right? So, or in the approach, it's always the same. You need to assess your risk, you need to manage your risk, you need to mitigate any risk there is, and you need to implement a whistleblowing system, basically, that enables reporting. And you need to do the reporting. Now, the European directive, as it's being discussed currently, goes beyond what the German law requires. So it doesn't focus on the number of employees, but it has a much lower threshold, so 250 employees and only 40 million turnover. You would already fall under it if you are a EU company. Or if you are a parent company, you have more than 500 employees and a worldwide turnover of more than 150 million, you would also fall under it. The reason why they implemented this, and it's something that we also have in Germany, the legislator wanted to prevent companies from structuring themselves in a way to escape the reporting obligations, right? Instead of, for example, if you have a threshold of 3,000 currently, and a company with 4,000 employees, they could, in theory, set up multiple companies with a holding on top and escape the threshold. And that's not the case neither under the German, but also not under the European directive. It's always the highest, in the German case, the highest German entity, the parent company that accumulates the employees below of the different entities. Or in the case of the EU directive, it would be the EU parent company. Interestingly, the EU directive also covers non-EU companies with an annual turnover that is more than 150 million, if at least 40 million were generated in the EU. So my guess would be, currently, I can't think of any Brazilian company that would fall under the scope of the German legislation, and that is operating in Germany to that extent. But under the third limb of the EU directive, I'm pretty sure that there are companies that would fall within the scope. And the last slide that I wanted to highlight is the substantive scope of the directive as it's currently being debated. So similar to the German Act, we are talking about, or the directive, the draft is talking about what are the appropriate measures that a company needs to take in order to identify, prevent, mitigate, bring to an end, or minimize potential impacts on human rights as a result of their operations. But the difference is that this relates to the value chain. So it's not only the supply chain going down, but also what happens to your product that you sell. And that makes it extremely difficult, I would say, for a company. I mean, that's highly debated currently. And there's a lot of opposition from corporates because they say it puts too much of a burden on them. And the relationship, and then because it refers to value chain, there doesn't need to be a contractual relationship, but it's established business relationship. So if you have multiple dealings with an end customer, that would already be counted as an established business relationship. So it is quite broad. And maybe to come to the end and then start the discussion, the running up to the German legislation was actually very quiet. There was not much opposition. Corporates were actually thought, okay, we'll be able to handle it, to deal with it. Now that the law is there, there's a lot of opposition mounting because, first of all, the German corporates say, well, it's really unfair that we have to deal with it and none of the other European companies have to deal with it. Now that the European draft is out, all of the European companies, they see the German precedent and they say, this is completely unreasonable. I mean, we are requested to follow down our supply chain. We have no idea what the supply chain looks like, to be honest. Why should we as Europeans do it and no one else in the world does it? So there's a lot of discussion going on. My gut feeling is that we will see the directive, but it's definitely not set in stone. So I think that was a very quick run through a rather complex law that is also not very clear and very precise in many aspects. I mean, if you talk about human rights, it is a bit more complicated than if you have a certain standard, i.e. a technical standard that you can compare to and refer to. But it's at the same time, I think it's a topic that will not go away. This law relates to human rights, but similarly, we have discussions about the non-financial reporting directive. We have a new regulation about only permitting imports of agricultural products that are not from deforested rainforests. So it's a wider discussion that is also linked to the whole topic of ESG, global warming, energy transformation. So it will not go away, but at the same time, the question is, and I think that brings me back to what you said, Raphael, in the beginning, how should it be enforced? How is it enforced? And how can you create a level playing field if you want to do it globally, if we're talking about global markets?
Dominique, first of all, I'd like to thank you so much for a very clear presentation. The topic is so interesting. I mean, we've been discussing, right, Rafa and Cisa, and I think Mariana is also here and other of the coordinators of our group. We have been discussing that compliance programs have so much to offer to the companies in terms of risk prevention, detection, and response in other fields than not only corruption. I think it was very, very good presentation for us to take a look at one of the risks that probably it's going to be affecting companies going forward. I do have a whole bunch of questions. However, I'd like to open the floor also to Rafaela and Cisa and see if you guys want to go first, or if I should make my questions here or if I first.
I love the presentation, and I have so many questions that I think I'm going to need to reach out to Dominique after the panel. But first, I'm interested in understanding if you have any idea on the timing of the directive, because I found it interesting that you said that other German companies are complaining about the fact that the other countries don't have such a law, and they are being disadvantaged somehow because they have to comply with more. So any idea on timing? And I would like to hear a bit more about what German companies have been doing to comply with the new law as well.
Sure. Great question. Well, about timing, my gut feeling says that we'll see the directive being passed either before the summer break or right after the summer break.
Oh,
and then you have a transition period of 2 years usually. That being said, it's been exactly the same with the German law. So you had a 2-year period between the passing of the law and the law coming into force. And interestingly, what happened is there were a couple of front runners. A couple of our clients, they were very, very well advanced, and usually the ones that also had a very sophisticated compliance management system and risk management system. So they thought about very early, what does it mean for us? What do we have to do? How do we deal with it? And there were a couple of strategic discussions on their side. They said, okay, for example, the law requires, if they are big multinational corporates, the law only applies to the German entities. What do we do with our entities abroad? Should we bring them into the scope of the legislation, or should we leave them out? I think the result is, or what we see in the market is that there is not one size fits all, but the more, or depending on how the risk management system is structured, we also have clients that decided to bring all of their entities into the scope, because they said, how should we define, or how should we track how products are shipped, intercompany sales take place, and then follow through the supply chain? It's almost impossible. For us, it's a lot easier to implement the vendor. I mean, they already have the third-party tracking system in place. So for us, it's easier to ensure that all our suppliers are within scope, and that we have the oversight, and that we can do proper reporting, then do a piecemeal approach. So those were the front runners. And then interestingly, 1st of January, the law came into place, and all of a sudden you had multiple companies that were clearly within scope, and that they said, oh no, what do we have to do? And then to implement a risk management system is quite complex. It takes time, and it takes a lot of stakeholders. And I think the big difference, and the biggest difference that we see in compliance generally, but when it comes to this human rights topic in general, non-financial reporting issues, there's not a single department that can handle this task on its own, right? So for example, if you talk about human rights, you need procurement, you need HR, you need quality controls, you need management buy-in, and you need to bring them all together. So it takes time, and it takes resources. And I think a lot of companies are struggling with it at the moment, because they started too late, and they see that the multitude of information that they receive, sometimes they don't know what information they actually have. And sometimes they are struggling to then compile it into a succinct report. So they are struggling a bit, but I think they will get there. And I think the good news is that also the regulator is struggling with the number of reports that they receive, but also the number and the complexity of information. I think that's what the regulator underestimated a little bit.
Thank you, Dominique.
Okay, I will also choose between my questions here, and if any of our attendees would like to pose some questions, also you can do that in the Q&A. Dominique, I think there are some things I'd like to confirm and see if I got it properly. One thing is on the human rights officer you mentioned. I understood that it doesn't need to be someone that will only have this specific role, right? So I'd like to listen from you. What are the companies doing? Are they putting the chief compliance officer in charge of that, or are they putting the sustainability officer in charge of that, or is the CFO, or is anyone else? Is the general counsel who's generally taking this role? Also, you mentioned difference between the European legislation and the German legislation on which companies would be in scope, right? And on the German legislation, should I consider, for example, if there is a German company that has investments in other companies across the globe, but for example, this German company may or may not control such investments. Maybe they have 50% of stake, but they do not control. Would that be the case? Would that qualify? So what's the definition here? Was that the economic group would qualify even if there is no control? So because I think that can affect a whole bunch of companies that are operating in Brazil, right? And finally, I think my third company is here. My third question here would be, you mentioned the investigations that the legislation in Germany will provide for some details on how investigations should be conducted. I'm not sure if I got that correctly. If that's the case, just for you to give us an overview on what's the regulation saying about such investigations.
Sure. No, sure. Let's try and run through. So first question regarding the human rights officer, that's exactly right. The law provides the example that companies can implement a human rights officer, but they don't have to. So for example, some clients, they use a committee instead of a single person because they say the issue is so complex, rather than burdening it all on one person, we are better off having a multitude of expertise, bring them all together in a committee, and then they create a reporting jointly. The Act also doesn't specify what qualification you need, but it says you need to have sufficient qualification and you need to have access to senior management. So usually that means a direct reporting line to senior management. And it would mean, in our interpretation and what commentators have said, multiple years of experience in the field, possibly qualifications, but it doesn't have to be a lawyer. It doesn't have to be an auditor. So there's no requirement on the background. And that is that is an example of where the law is actually quite not very precise, and that leads to a lot of discussions. So we had clients where the regulator actually came back with the first enforcement questions, and they said, all right, we want to know who is your appointed person or your appointed committee? What are the qualifications? What have they been doing? Why have they been doing it? Do they have the necessary capacity? Because you asked, can it also be the chief compliance officer? Yes, in theory, it can be the chief compliance officer. And there are multiple examples where companies have appointed the chief compliance officer or the GC as also now human rights officer. And that all works until you have an enforcement action, because then you will have a difficult time arguing that a person that was at 100% capacity before they were appointed human rights officer still had the capacity to do that job in addition. What companies try to do, and that is, I think, a key message in the whole act, it's all about documentation. So, for example, if you have a very busy GC or CCO that's now also becoming human rights officer, what is the strategic plan to enable that person to fulfill that role? It would be, for example, that you clearly show what are the resources that are available to this person. Does that person has access to, for example, external consultants or internal consultants that do the work, prepare the work, do the research for that person? And basically provide the information, just like senior management gets information and has sufficient resources. So if you are able to show that, I think you have a good argument towards the regulator, but it's something that companies should think about. The second question is exactly regarding control, is exactly as you said. The law provides for, it says companies have to have a controlling interest. It's controlling interest. It's not in the corporate legal sense, i.e. 50% plus, but the law contains reference, for example, is there a central risk management or compliance management system? Is there a central reporting? Is there key resources that are shared? So if there's a factual control in operation, that would be a controlling interest. But that's what the law says, and it hasn't been litigated in court because it's so new. Our view is that the law is quite imprecise here, and there will be a lot of discussion about whether there is a controlling interest or not. And also you have a lot of jurisdictions where from a corporate perspective, if you have a corporate entity, you are not even allowed to control that entity, right? So it's management that needs to act independently. So there are also, from a corporate perspective, a lot of arguments that you can bring against it. And it will certainly end up in court, and we'll see a lot of litigation on that point. And then the third one relates to the question of investigations and what is required under the Act. And this is an interesting one because the Act requires you to, when you have indications of that something is going wrong, you need to investigate the cause or verify whether that's actually the case or not. So you would usually do that, for example, by means of, for example, an internal investigation. And then if you come to the result that there is a shortfall or something is going wrong, you need to mitigate the risk or you need to end the breach. And that is, the law is stricter with regard to your own operations as well as the operations of your direct suppliers. With regard down the supply chain, it's a phased approach, right? So what you should do is, depending, the law says it depends on your actual influence. So if you are, I don't know, the Apple or Microsofts of this world, and
the main client of that supplier,
exactly, and you have a dominating influence on that client, you are held to a higher threshold than if you are just number XYZ in the supply chain, and your factual influence is almost null, because if you don't buy the product and it can be sold to another entity, then that's it.
Right. I think we're reaching time. I still have like 44 more questions, but I will do as Rafa said. Probably I will take it offline.
Maybe when the European directive is approved, we can make a new conversation.
That's a great idea, Cecilia.
Put in your agenda, Dominique, please. It was very good.
Thank you very much. It's been a pleasure, and I think it's interesting to see. And last time I was in Brazil and talked about the law, what I found really interesting was to see that, well, at the moment, only German companies are in scope. There are hardly any company in Brazil that does business with Germany that hasn't heard of it, because basically the companies in scope, they push down the obligations down the supply chain. And then the question is, how do you deal with it in practice?
Yeah, I think a lot of Brazilian companies are also afraid that they'll lose market. We have discussions between the EU and Mercosur on the treaty. We have discussions a lot of the sustainability part for the Brazilian agribusiness, and I think this human rights regulation is also calling for attention in Brazilian companies. Dominique, I'd like to thank you so much. I think it was great. A lot of the points you brought for me, as someone that comes from anti-corruption enforcement, for example, you said a lot of the German companies are complaining that only them in the world are obliged to do that. I think Rafa also we remember that a lot of the American companies were saying that when the FCPA was approved. So there are similarities. And maybe that's why also it took some years for the FCPA to actually be well enforced in the US. But I mean, it was very interesting to hear from you, and thank you for taking our questions. From my part, it was very informative and actually a lot of fun. I think it's a great legislation, and probably is showing us some tendencies. Thank you for your presence. I don't know, Rafa, Cisa, can we let Dominique go, or is there anything else we need from him?
No. Thank you, Dominique, once again for coming and stay with us and tell us everything so about the new German law, and also with this link with Raphael Soré that gave the precision scenario. But as I said, I think when the European directive is approved, we can schedule another conversation, because then I think more companies will be present, especially here in Brazil, to be in compliance with the new legislation. As Rafael is saying, the new FCPA, but Dominique says not yet the FCPA.
Right.
Okay. And then we can learn more about like the enforcement activity, if there's what it's going on.
Yeah, and the investigation too.
Perfect.
Thank you a lot,
Thank
Dominique.
you very much for having me.